Hello and welcome friends. Till this module, we discussed many things associated with the air pollution and control. In this particular module, we wish to discuss about various international treaties that have been signed in order to establish the control on air pollution internationally. So here we'll discuss about the definition and significance of international environmental agreements, the procedure for formation of the treaties, and major international environmental agreements associated with the air pollution. So as you learn the content, you will be able to define and explain the significance of international environmental agreement, as well as state steps that are involved in the formation of the treaty, and also state the provisions in major international environmental agreements associated with air pollution and control. So initially, let's try to understand the significance of international environmental agreement. These agreements are signed treaties to regulate or to manage human impact to protect the environment as a whole. These international treaties have got very specific meaning, and hence its definition is given under the Vienna Convention on the Law of Treaties 1969. It says the international treaty is an agreement concluded between the states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. Please note the specific terms that are underlined. So the first term is telling us about the international agreement. That is, it is an agreement between the countries. It is concluded between the states. In order to define a state, it has to have some permanent population close by territory. It must have its own governance, as well as it must have its capability to deal internationally. Such states cannot enter into the treaty simply by showing oral consent, but it must be in written form. This treaty is said to be governed by the international law. That means if it is not followed, if it is not followed to the extent of the agreement, the party which is entering into would be punishable. Here we treat this instrument as act or the provisions of that particular law, and hence related instruments, which could be one or two, or it could be more. Also, there could be an official or an authority which would be handling on the behalf of that party which is entered into the treaty, and hence it is expected to have that particular designation. Thus, this treaty is an instrument which creates the legal rights and obligations between the signatory to that treaty. Any nation needs to be signatory to a particular treaty for its effective implementation. So, all that particular agreements may not be mandatory. However, if a particular nation is interested for the effective implementation of it, that particular nation has to be party to that treaty. Also, these agreements enable countries to work together to address the particular environmental issues that could be transboundary or global in nature, such as, for the present context, maybe air pollution, climate change, protection of the ozone layer, and also the ocean pollution. India is party to many such international agreements concerning the management of the environment. The International Environmental Agreements Database Project separates the environmental agreements into various categories. The category, the pollution and climates, covers the pollution of the air, land, ocean, and freshwater systems. These environmental agreements could be signed between the countries in order to express it as bilateral environmental agreement, or it could be signed between 3 countries or more than that in order to make it multilateral environmental agreements. So, in 1972, the United Nations Conference on the Human Environment, which was held in Stockholm, started an agreement in order to express the comprehensive international effort to protect, preserve, and enhance the environment. Since then, lot many environmental agreements have been negotiated. With this particular agreement, we should be conversant with the few of the terms. So, convention is a tool that is gathering of the people who are coming together with common intention. That can be group of the countries. So, this convention can refer to actual meeting or conference of the parties where they reach an agreement on the final terms of treaty. Usually, if that particular convention is to be further supplemented, if it is to be further amended, then protocol comes in the picture. So it creates certain additional restrictions, or it lays down certain additional standards subsequently with the due consent of all the parties that are involved in that agreement. Some original signatories of a convention are not automatically bound to the protocols without the separate ratification. So when a particular state is entering into the agreement after its completion of the internal processes, it expresses its consent to the involved parties, and hence that decision is said to be ratified. However, as various parties enter into these particular environmental agreements, their subsequent assessment of the implementation, compliance, as well as effectiveness of the various agreements is very complicated, and hence it could be a real situation that not much could not be known about the many countries' compliance with the agreement in which the various parties have entered into. As you see in this case, since 1850, many agreements as well as protocols and even the subsequent multilateral environmental agreements have been entered into over the years. As per the database project, there are more than 1,300 multilateral environmental agreements, over 2,200 bilateral environmental agreements, and 250 other environmental agreements, and more than 90,000 individual country membership actions as per 2017 data. As you see in this particular graph, since 1900 till 1990, the trend of signing these particular agreements is continuously increasing. However, as we consider after this 1990, the trend appears to be decreasing. If we enter into the various background and their implementation and compliance status, it is experienced that all the parties that have entered into that agreement may not be performing to the required extent. The data that have been generated may not be giving the factual picture, and hence most of these particular agreements are failures. Also, all the parties that enter into may not be contributing to the required extent, or sometimes they may not be paying towards their share at all. Hence, this is kind of free rider activity leading to the failure of such agreements. And hence, these parties may not be always continuing with entering into the agreements which could be one of the reasons for reduction in signing these environmental agreements. In order to enter into this environmental agreement, one must go through the steps that have been accepted internationally. So, the parties which are interested in entering into a particular treaty, they will be coming together and they will be discussing about the pros as well as the cons of that particular topic associated with the treaty. Hence, the draft is prepared and number of changes are made in order to have the mutual agreement. So this process is very lengthy. If it is bilateral, it could be taking small time. However, if it is multilateral, it could be taking very long time, sometimes even years. So this is first step, which is termed as negotiating and drafting. So as this particular draft is finalized, the next step comes, which is adoption and authentication. So whatever that particular draft is prepared, that draft is agreed upon the parties entering into, and they sign the text that is created through the step 1. So as this draft is agreed upon and signed, now they can express their content. So this step is associated with binding by that treaty. So this could be simply expressed by signature, or it could be with the exchange of the instruments. It could be the process of the ratification that we discussed about the state ratification, or it could simply be accession or approval. That is, the party may not be entering into the negotiating, drafting, adoption or authentication, but this step, those skipped, they may be able to adopt the draft which have been drafted and authenticated by other parties. As such, that could be accession. So as this step is complete, the treaty takes formal legal effect, and hence this step is called as entry into force. So after certain number of states have completed the process for the treaty, it becomes law for that particular state, and hence after entering into the force, this state which is legally bound by the treaty becomes the state party, and hence it is called as a state party. Having the background of this treaty, their categories and the steps that are involved in the formation of that treaty, let's understand the features of some of the treaties have been signed internationally. So this is Montreal Protocol on ozone depleting substances, entered in 1985. So we know, as we had the discussion about the composition of the atmosphere, there is a troposphere extended approximately up to 10 kilometers, and over that there is a stratosphere extended up to 50 kilometers. So the immediate layer above the troposphere and the bottom layer of the stratosphere indicates the presence of ozone. So this ozone layer is a barrier which is protecting all the environment, or especially the bio component of the earth, through the action of the ultraviolet rays which are reaching the earth's sphere as a part of harmful content of solar rays. Based on the various scientific studies, since about 1970s, there was observation in the depletion of this ozone layer. And hence, during 1977 to 1981, United Nations Environmental Program concluded a world plan for action on the depletion of ozone layer. This protocol is aimed at reduction in the production and consumption of ozone depleting substances, abbreviated as ODS, and it came into the force in 1989. Especially the chlorofluorocarbons, chlorine, bromine, are responsible for the depletion of ozone. Hence, there is a necessity to have these emissions reduced globally. This protocol recognizes the obligation of nations in reducing the emissions of these ozone depleting substances in terms of financial and technological abilities, and identifies the countries that are larger contributors than others. This protocol resulted in ODS Rules 2000 in India, and it categorized 95 ozone depleting substances in groups with their ozone depleting potential. This has resulted to prevent about 280 million cases of skin cancer, according to Environmental Protection Agency report on ozone calculations. In order to supplement the protocol, the Ministry of Environment and Forests for Government of India has formed an ozone cell as well as constituted a steering committee on the Montreal Protocol in order to implement the India Country Program. Next one is Helsinki Protocol on the sulfur emissions that took place in 1986. We know that the sulfur emissions are mainly associated with the major industries as well as burning of the fossil fuel. This is responsible for number of respiratory diseases, and it also interferes with the plant growth. Hence, this protocol was implemented by European Monitoring and Evaluation Program. It has been agreed that parties shall reduce their national annual sulfur emissions or their transboundary fluxes by at least 30% at the earliest possible and at the latest by 1993 in relation with the base levels of 1980. This protocol was entered into the force in 1987 with the contribution of 21 Economic Commission for European countries, and as the data was monitored, all parties that have been entered into this protocol could reach their target in the given period. Hence, this protocol is supplemented by 1994 Oslo Protocol on further reduction in the emissions of sulfur. In 1988, SOFIA Protocol to control the emissions of nitrogen oxides was proposed. Very similar to the oxides of sulfur, the oxides of the nitrogen are responsible for the respiratory problems, as well as it also interferes various ecosystems. It is mainly associated with the burning operations as well as automobile industry. This protocol was adopted in SOFIA, and the first step to this protocol was to freeze the emissions of oxides of the nitrogen or their fluxes occurring transboundary. The reference year was taken as 1987, and very similar to the Helsinki Protocol on the reduction of sulfur emissions, this SOFIA Protocol also have reached the target and stabilized the emissions in relation with 1987. So the second step to this NOx protocol required the application of effect-based approach, and while implementing this, the importance is given to the contribution to the photochemical pollution, acidification as well as eutrophication, and the effects of the oxides of the nitrogen on the human health, environment and materials by addressing all significant emission sources. Geneva Protocol was proposed in 1991 in order to establish the control on emissions of volatile organic compounds. These are mainly associated with the chemical industry, petrochemicals, as well as even the paint industry, and the pollutant is responsible for the irritation of the eyes, nose, throat. Also, it damages liver, kidney, as well as even the central nervous system. So, seeing the harm caused due to these VOCs, in November 91, the protocol to the Convention on Long-Range Transboundary Air Pollution on the control of VOCs and their transboundary fluxes was adopted. It has been determined to take the effective action in order to establish the control by applying appropriate national or international emission standards to mobile as well as stationary sources, retrofitting existing major stationary sources, as well as by limiting the content of the components in products for industrial and domestic use, which have the potential to emit volatile organic compounds. United Nations Framework Convention on the Climate Change is an agreement between 197 countries of the United Nations. This treaty was negotiated at the Earth Summit held in Rio de Janeiro during 3rd to 14th June 1992. The climate change is treated to be global disaster. As we had the discussion in few of our last discussions, it is causing harm in many manner to Earth as a whole. The changing rain patterns, desertifications, causing tsunamis, untimely rains, the effect of rising the ocean levels, and similar things have been attributed to this climate change. And hence, number of treaties have been signed in order to reduce the effects being induced due to the climate change. In view of this international treaty, India entered into this treaty on 1st November 1993. This treaty is directed towards the specific objective, which is to stabilize greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the global warming and climate change. This framework aims to regulate greenhouse gas emissions through international cooperation and agreement to bring down the emissions to reduce the probable impact. India has commitment to the participate in multilateral negotiations under this framework with the Paris Agreement 2015. Here, India has shown the leadership in moving ahead with the policy framework, which includes the National Environmental Policy and National Action Plan on Climate Change. The subsequent monitoring exam mechanism is Conference of the Parties. So the representatives of the various nations, representatives of the various parties that are entered into or which have the common interest, or certain agencies which are monitoring the effects that are causing, will be attending this conference of the parties, which is series of conferences in fact which are taking place since 1995. Through these conferences, the progress made by various members is reviewed. This kind of the agreements are not binding, however, they are in the interest of all the common beings and hence are voluntary. As mentioned above, this conference or series of the conferences are taking place since 1995 yearly. If not agreed by the parties, then and then only under some undue circumstances, the conference may not occur. Recently, the Conference of the Parties 26, that means it was the 26th event of the countries, was held in Glasgow, Scotland during 31st October to 12th November 21. In this conference, it was agreed that the parties will meet next year to pledge further cuts to emissions of the carbon dioxide. Also, to phase down rather than to phase out the coal after late intervention of the China and India. Most of the parties were interested in phasing out the use of the fossil fuel coal. However, China and India were not very firm on this kind of the decision, and hence it was resolved to phase down the use of the coal. Also, it has been agreed to enhance the financial contribution to help the poor countries to cope up with the harmful effects of the climate change and to switch over to the clean energy. One of the agreements was to phase out the subsidies that artificially lower the price of the coal, oil as well as natural gas so as to reduce the use of fossil fuel. The subsequent agreements are to stop the deforestation by 2030 as well as to cut the 30% of the methane emissions by 2030. In continuation, in 1997, United Nations Convention on Climate Change, which took place in Kyoto and signed by India in 1997. This was adopted in 1997. However, it entered into the force in 2005. This protocol supplements 1992 United Nations Framework Convention on Climate Change to limit the emission of greenhouse gases. It recognizes that especially developed countries are more responsible for the high levels of greenhouse gas emissions in the atmosphere as compared to the developing nations and poor countries. Hence, it is said to be based on the principle of common but differentiated responsibilities. It tells us that the pollution caused due to the emissions of certain pollutants is the responsibility of all that are involved. However, the responsibility of all the involved is not equal, and hence it is differentiated. According to this protocol, there is a specific target to reduce the emissions of 6 greenhouse gases, mainly carbon dioxide, methane, nitrous oxide, hydrofluorocarbons, perfluorocarbons, and sulfur hexafluoride. 37 countries and European Union participated in the first commitment period until 2012, and subsequently 192 members have entered into the agreement. The Doha Amendment is the second period of the agreement, and it has ended in 2020. The Basel Convention, which was suggested in 1989 and signed by India in March 90, is designated to reduce the movement of the hazardous waste between the nations, especially from developed to less developed countries, which will be indirectly helping to reduce and to deal with air pollution problem. This convention is intended to minimize the generation of the toxic waste, to ensure the eco-friendly waste management as close as to the source and to assist less developed countries for waste management. India further ratified to the treaty in 1992 and included some provisions of this convention in the Indian Hazardous Waste Management Rule 2008 and even their earlier version. Another protocol is Stockholm Convention on Persistent Organic Pollutants. These pollutants are carcinogenic. They cause the suppression of immune systems that also interferes with the neurobehavioral function and also cause of hypertension. And hence, this particular treaty focuses on the control of POPs. According to this, it has been agreed to eliminate the use of identifiable POPs at earliest, but no later than 2010 and or 2015. It has been agreed for the destruction of these POPs in environmentally sound manner, as well as disposal of the related equipment in environmentally sound manner. Lima Climate Change Conference took place in December 2014. It provides the greater transparency for the actions taken by the developed countries, as they can compare their degree of compliance with the emission reduction goals. So some measurable outcomes of this particular conference can be developing country parties and their invitation, with least developed countries in order to know the outcomes of the processes for the implementation of the National Adaptation Plan on Climate Change. With this conference, it has been also agreed to submit the CO2 emission information by March 2015. The controversial issue of common but differentiated responsibilities was also discussed between developed and developing countries. As we discussed earlier, all the nations who are entering into the agreement are liable to take the advantage of the processes that have been adopted as a part of national adaptation plan on the climate change. However, all may not be contributing equally, or some may be contributing very little or not at all. And hence, there is common but differentiated responsibilities. Hence, the focus on this conference was more global and did not address individual countries' development. It was also resolved to provide the funding for the Green Climate Fund in order to enable various developing countries to go for more greener technologies to combat climate change. In December 2015, the Paris Agreement was proposed. This is an international treaty on the climate change, which is legally binding. It was adopted by 196 parties in Paris in 2015 and was entered into the force in November 2016. The goal of this agreement is to limit the global warming to well below 2 degrees centigrade, preferably to 1.5 degrees Celsius compared to pre-industrial levels. To achieve this long-term temperature goal, countries aim to reach global peaking of the greenhouse gas emissions at the earliest to achieve the climate neutral world by mid-century. This agreement is a landmark in the multilateral climate change process because for the first time a binding agreement brings all nations into a common cause to undertake ambitious efforts to combat climate change and adapt to its effects. So thanks for your attention, friends. I hope the meaning of air pollution treaties, the conceptualization and the categories of these particular treaties, the meaning of the various terms that are involved in the treaties, and some of the treaties that have been suggested, adopted, entered into is clear to you. So as we move ahead, we will discuss about the air quality programs. So bye till then. I wish you very happy learning. Thank you.